talking about a ballot proposition that won't be on our ballot come November, and it should have been, and it would have been very exciting, but we're going to find out what that's all about. That would have been Proposition 49, the so-called money out, voters in proposition. We're going to learn what was in it, why it was important to have it, why it got kicked off the ballot, and where we go from here. And joining me to talk about this are two activists with the Yes on 49 campaign. At the far end of the table is Bruce Preville. Bruce, welcome to Other Voices.
Thank you, Paul.
And sitting next to me and returning to this program is Eitan Fenson, also with Yes on Prop 49. Eitan, welcome back.
Thank you, Paul.
And thank you both for being here. So let's get a quick rundown of what Proposition 49 said and what people might have had the opportunity to vote on. Let's start off with just what was in the proposition.
Bruce, do you want to hit that one?
I think you can do a better job
All
of
right.
it.
Oh.
You've got all the details.
Oh, this is a good start. They're arguing over who's going to...
Prop 49.
You go.
Well, let me say something first. I think this is important to set the context. Proposition 49 is one of the strategies for getting the corrupting influence of big money out of our democratic process. And there isn't any easy solution to that. In fact, there isn't any. There are lots of ideas, but none of them are extremely likely to be successful. And none of them, if they are successful by themselves, will be enough. So we're going to have a lot of attempts, and there's going to be a lot of failures, and there's going to be a lot of pushback. After all, there's a lot at stake here.
That's right.
So the fact that this didn't pass is not a huge failure. It just means it's one more step on the path.
To be specific about Prop 49, it is a statement that the legislature has the authority to regulate the expenditures and donations in political campaigns. In addition, it stipulates that only human beings have constitutional rights. This was a measure that was passed by the state legislature. And Governor Brown did not sign it. What he did instead was he said, you know what, I'll let this become law without my signature, which it did. And
what they passed was to put this measure on the ballot.
On the ballot. So clearly Governor Brown was not, shall we say, excited enough about it to sign it, which indicates, as Bruce said, that none of our paths is that straightforward, but it was ultimately, it was made into law, and the Supreme Court decided to stay its presence on the ballot pending a decision on a suit brought by the Howard Jarvis Taxpayers Association. The initial ruling by the Court of Appeals was they threw the case out. Jarvis appealed to the Supreme Court, and the California Supreme Court voted 5-1 to stay its appearance on the ballot. This was on August 11th, the last day that it could be printed.
So Prop 49 would have instructed our legislators in Washington, our representatives and senators, to support efforts basically to amend the Constitution to say corporations are not people, money is not speech. Is that correct?
Yes, in a nutshell.
In a nutshell.
It was an instructive measure. And by the way, that wording, instructive versus advisory, is of real importance as far as the legality is concerned. But it did instruct our elected representatives, both in Congress and in the state legislature, to number one, propose an amendment in Congress, and number two, ratify that amendment by the state legislature. That is of itself not binding. It is not legal for the voters of any state to tell their representatives how to vote on a particular measure, whether it's an amendment or a law. So in that sense,
let me correct that. It's legal to tell them how to vote, but it's not legally binding on them.
Correct. That is correct.
I mean, if it was illegal to tell them how to vote,
No, that's right.
I'd be in deep trouble for.
That's correct.
So, Bruce, why did the Supreme Court, what was their finding that they haven't made a final decision yet?
They haven't decided.
It's run out of time to get it on this ballot. The suit will go ahead to consider it for the 2016 ballot, correct?
Actually, it's not to consider it for the 2016 ballot. The consideration is whether it would have been legal to be on the 2014 ballot. So
if they end up deciding that it was a legal measure,
then we'd have to go through the process again.
but one
the
step
court-
forward, two steps back.
The court could conceivably be creative and rule in some synthetic fashion, but that's not likely.
Yeah. So what is the legal position here? As I understand it, they said this is an advisory measure, and those aren't allowed on the California ballot. Is that right?
One of the California Supreme Court justices said that if they wanted to give their advice, the public could do a public opinion poll. That's kind of the extreme view of this as advice like that.
Well, the real issue here is Article 2 of the California Constitution. Article 2, Sections 8 and 9 cover both ballot initiatives and referenda in terms of what is actually supported by the California Constitution. Section 8 stipulates that citizens' initiatives, measures that are put on the ballot by signatures, cannot be advisory. They must either create law or amend the California Constitution. Section 9 talks about referenda, where the vote is on an existing law, whether to affirm it or to reject it. And there is mention of having that done as a result of legislative action, but it's somewhat vague. Nowhere else in the Constitution is there an explicit description of the legislature putting a measure on the ballot. On the other hand, the Constitution does explicitly say that anything not indicated, any action not proscribed by the Constitution for the legislature is enabled by the legislature. So the question as to whether or not an advisory measure can appear on the ballot is not simple. When we decided in our local Move to Amend affiliate, we actually went through this discussion about a year and a half ago. The National Move to Amend organization wanted to put a measure on the California ballot. And they, excuse me, and they wanted to put that measure using signatures. We in the Santa Clara affiliate looked at the California Constitution and concluded correctly, we believe, that if we had collected signatures and put the measure on the ballot, it would have been struck down. And as in fact it was struck down in this case.
Yeah, but you'd have been out $500,000 and all those signatures. It's not easy to collect signatures.
That's correct. That's correct. So the real question is whether the legislature can put a measure on the ballot that is advisory or, as you point out, instructive, which Derek Cressman, who is the campaign manager for Prop 49, he likes to point out very explicitly that it is instructive as opposed to advisory. But these are nuances in law, and it's not really clear, at least to me, being an advocate, it's not clear what the correct interpretation is, although being somewhat biased, I believe that the court should have ruled in favor of having the measure on the ballot.
Was the legislature aware of this pending possibility that it could be kicked off the ballot, or were they pretty sure that the instructive nature of it would cover them?
That's a very good question. I certainly don't know the answer.
Because, you referred to Jerry Brown letting it go into action without his signature, and I read his letter, and I took in the letter that he didn't necessarily disagree with the goals of.
No, he explicitly said he agreed with the goals.
But that he felt that it was an advisory measure, and he didn't think that the ballot should be cluttered up with such measures, and that's why he let it go into law without.
He said explicitly that he did not want to set a precedent. He did not want to set expectation that in the future he would sign initiatives put on the ballot that are advisory. But by the same token, he said he thought that this issue warranted being on the ballot.
Well, that's good to know. Now, previously, I think it was last year that the legislature passed their own resolution, very similar, saying that they supported a constitutional amendment. Is that right? Can you talk about that a little bit?
They did not.
No.
They didn't vote. They didn't vote to support a constitutional amendment. They voted to support a constitutional convention, which is.
Is that what that measures?
They did that in this last session. They voted to call for a constitutional convention, which is, in my opinion at least, it opens a can of worms. And it's not something that I personally support. I believe that the national leadership of Move to Amend is divided on that. I don't believe that there is any kind of consensus among the activists that that's the right thing to do.
Yeah. Let's go through the rules for amending the Constitution, just so people know what we're talking about here. And
Article 5 of the U.S. Constitution basically provides for two methods to amend the Constitution. The first one, which has been the one used for all 27, is that 2/3 of both houses of Congress, or each house of Congress, needs to pass the amendment. Then it needs to go to the states, and the state legislatures of 3/4 of the states need to ratify that amendment. When that happens, it becomes an amendment. The other method is somewhat murky. It is not explicit, and in fact is one of the reasons that I have problems with it. And that is the 2/3 of the states call for a constitutional convention, in which case there is a convention, an amendment is drawn up, and then that amendment needs to be ratified again by 3/4 of the state legislatures. So some people claim that that is, in some sense, a safety valve. That whatever the constitutional convention comes up with, the 3/4 of the states still need to ratify it. The problem I have with it is there is no specification in the Article 5 about how such a convention is managed. Who gets to run it? Who gets to be the representatives? Who gets to draw up the amendment? Can it be limited to one issue? None of that is specified in Article 5, and so, in my opinion, it's something I would just soon leave alone.
And another important question is, who pays for the corporate hospitality suites of the Constitution?
There's always that.
So, Bruce, let's get you in on this. If Proposition 49 had been on our November ballot, what would have been the hopes of the campaign to vote yes on it? What would have been the message, and how does this play politically into moving forward the national effort to amend the Constitution?
Well, there have been somewhere around 28, I think, states. Is it 28? You're the numbers guy. Something like that.
I don't know the answer to that.
I believe it's 28 states and like 300 municipalities have passed something like this that says this needs to happen. And the states, there are, I think, 4 or 5 states that are considered to be conservative states, red states, that have passed this. The voters are, in those states, they voted like 75% in favor of it. In the other states, the more liberal states, they're like 80 or 85% voting in favor of it. So there is a groundswell of support. There is a need, there's a felt need on the part of us regular people to make something happen. So this is one step in a national campaign, or I don't want to call it a campaign because it's not so essentially a movement, an uprising, if you will. It's one step among many that is happening at the local city level, at the county level, at the state level, at the national level. And it just keeps building momentum. And one of the things I mean, this is all about building momentum, because to get, 2/3 or 3/4 of the states to all pass it, it takes a lot. I mean, trying to get Congress to pass something, it takes a lot. And nonetheless, the people in general so far have been saying, we want this, we insist on this. So the what is this is a little bit different from place to place. What it's going to turn out, how long is it going to take, what is the path to get there is uncertain, but the desire's there.
There are two essential elements. I know from having you and other folks on from Move to Amend that you are looking for in a constitutional amendment. First is the limiting the constitutional rights that corporations enjoy, especially under this.
Not limiting, eliminating.
Eliminating, okay. They still would have some legal rights as corporate institutions. Privileges. Okay.
Granted by statute.
Okay. And the other one is to stop treating money as a form of free speech. And the reason for requiring a constitutional amendment is that the Supreme Court has ruled the opposite way in both of those. So I'm going to hit something that's a little controversial, because right now in the Senate there is a bill that addresses Part 2, and it's tied directly to the Citizens United, and it's the bill for a constitutional amendment that says money is not speech. Now, there's a lot of back and forth in the movement. Should this be supported? Should it not? I know Move to Amend takes the position you've got to have both. Why? And talk about that a little bit.
I think you used the right word when you said controversial. The different members of the movement coalition do feel differently. In my opinion, and I'll speak for myself and also for Santa Clara County affiliate, the Senate bill sponsored by Tom Udall, I believe the wording of that bill is not what I would like for a number of reasons, one of which is, even in terms of money, it does not explicitly say that the spending of money is not the exercise of free speech. It uses language that I find somewhat vague, talking about regulating expenditures related to campaigns. So I think it's something that can probably be manipulated. Secondly, it says nothing about corporate personhood. There's also a bill in the U.S. Congress and the House of Representatives, of which our representative, Anna Eshoo, is a sponsor, that is pretty much identical.
Right.
The Move to Amend position is that we do not support either of those bills. And for the reason that I mentioned, largely because it does not address corporate constitutional rights, and also because the wording on campaign expenditures and donations is not what we would like. We'd like to see explicitly spending money is not the exercise of free speech.
Basically, a clarification of the First Amendment that says
Correct.
Money doesn't come under the First Amendment.
Correct.
So let's just, for the sake of argument, say that the Udall bill did have the money part worded the way you would like it. Would you still oppose it, or do you think they need to be done at the same time?
Move to Amend would still oppose it. I would personally probably still oppose it.
Because, I can see the point of people that are supporting it. It's part of what Bruce was talking about. This is incremental to get to a constitutional amendment. And it takes step by step. So if you can knock off one of these things, that doesn't mean you stop working on the other one and the game's over, does it?
No. I can tell you that the position of Move to Amend is it's hard enough to amend the Constitution once. Doing it twice is probably more than twice as hard.
Yeah.
The idea is that if you look at national polls, there is a pretty good consensus that large corporations have way too much power. And one of the tools that they use to exercise that power is corporate constitutional rights. So there is a very significant sense of the people that, as expressed in polls and some elections, as Bruce points out in Montana, a red state, in 2012, 75% of the electorate voted in favor of exactly the move to amend amendment. So we think that there is enough public
Where
support.
presumably advisory measures in Montana are legal.
They are.
Maybe we should start working on a move to amend the California Constitution. Just step back a little bit. All right, let's try to get our audience in on this. If you have a question or a comment, just raise your hand and wait for, where is our mobile audio person? She's getting the microphone. Okay, there's one right here. And if you would stand up and make it a little easier for our camera people,
Yeah.
and hold it close.
Of the 28 states that have passed measures, were these all by initiative, or some by initiative and some by the legislature?
Virtually all are by resolution, which is the state legislature passes a resolution saying we're in favor of this. The two that were initiatives were Montana and Colorado in 2012, that were explicitly exactly like what Prop 49 would have been. One of the reasons that we believe that the opposition to Prop 49 was so quick is that Montana and Colorado are not California. There would have been a huge effect of a vote like the one in Montana or Colorado in California.
Okay, and there's, well, got several going.
I think Alice had a question.
Yeah. We'll go here.
Yes, just a comment and then a question. The comment is that Montana had very advanced expenditure laws prohibiting corporations from doing exactly what was the effect of Citizens United, so that they already were on the right page
That's
to begin
correct.
with. The second point I would make is, in a blue state like California, when the state assembly does not get SB 52 out on the floor, I see no hope for reforming money as speech or anything else, because all the Disclose Act was going to do was simply say who had funded the ads. And it's so outrageous that money could have actually stopped through the labor union, the misplaced positions of the labor union
Yeah.
and the teachers union, the SEIU and CTA, that I see almost no hope in all this. Thank you.
Hopeless?
I agree with your sentiment. I do not believe that it is hopeless. It just means it's challenging. I am as frustrated as you are, but I believe that it's something we can overcome.
Something that gives me a sense of hope when it seems hopeless is a quote that I remember from Nelson Mandela, and he said, "It always seems impossible until it's done." It always seems impossible. And we want to give up. We say, it's impossible, look. And we give all the reasons, and we say, that's why I'm giving up. I mean, it's pointless, it's hopeless, I'm giving up. But what Nelson Mandela says is, it always looks impossible, all the way up until, like, you discover, oh my gosh, it happened, we succeeded. And it's not even we're going to succeed. It's almost after the fact. So it always seems impossible till it's done. And it takes a lot of courage to keep in the face of the impossibility and the frustrations. That's how it is. That's how the world changes.
Okay, down front here.
Okay, well, in fact, I think that when you introduced this, Paul, you said that we would be talking about what we can do now. And to me, that is much more important than
Right.
how pissed off I am about what's happened. So I would like to hear some specific ideas about what we should be working on at this point.
Let me report on.
Thank you, because that's where I was going to go next anyways.
Let me report on what the Yes on 49 campaign is up to. The California Supreme Court will have a hearing on November 10th, and it's going to issue its ruling. The ruling will be essentially one of three things. Either it will say that indeed this could not have been on the ballot, and so we're fine in having done what we did. Or they'll rule that, well, you know what, it could be on the ballot, and maybe we should in fact put it on the ballot in 2016. The other ruling, let's see, what was the third one? I lost my train. Anyhow, the bottom line is that on November 10th, they're going to make a decision. The MOVI / Yes on 49 campaign management has come up with a petition that we would like you to sign online. It's on the yesonca49.com website. Let the people vote. And it's simply an expression of frustration and indignation that the court forestall this vote. We would encourage you to do that moving forward. But given that, the Yes on CA49 campaign will virtually certainly come up with some measure in the 2016 campaign. If the court rules that it cannot be what it was, then it's likely that we will add something to the initiative that essentially lays out the gauntlet to the Supreme Court. It will change California law in a way that will probably provoke a suit and cause the Supreme Court to rule on that law, but it will create a law. So that's where the thinking is right now, that if in fact the court rules against Prop 49, we will have a measure on the ballot that gets past that objection.
The petition to the petition to the California Supreme Court, like some other states, California has retention elections for
Yes.
its Supreme Court justices. Their term is 12 years, but then they go on the ballot to be retained. And we all remember how Rosebird and two others actually lost their seats because of their staunch opposition to the death penalty many years ago. Do you look at the retention vote as any kind of leverage to work on this, or it doesn't sound like that's been part of the strategy?
You used the word controversial before.
Yeah.
That is somewhat controversial.
I like that word.
There are those in the movement who believe very strongly in voting not to retain either justice who's on the ballot. One of them is Goodwin Liu, who is a liberal progressive justice for whom many progressives feel would be ashamed to have him not retained.
Yeah.
Personally, I can tell you I understand the sentiment to vote against retention. I don't believe that that's something that we should focus on. Again, speaking personally, and I believe that there are those in the Yes on CA 49 campaign who agree with me, and there are those who don't. There is not a consensus in the campaign leadership that that is a direction they want to promote.
Okay, and I saw another question in our audience here, and the mic is on its way. And there you go, if you'll stand up.
I think that we haven't discussed the irony of this Jarvis challenge, because in fact Howard Jarvis was the person or the organization that brought Prop 13 to the ballot.
Right.
And now Prop 13 is causing the state judiciary to be strangled by money, lack of funds. They're closing courtrooms, cutting staff, and actually losing IT capabilities because they don't have the funding. And here the Supreme Court rules in favor of Jarvis, even though they've been strangled by Jarvis.
Any comments on that? Thank you. It's, and why was the Jarvis Taxpayers Association opposed to this? And they seem to be the only opposition out there.
They were not the only opposition
Okay.
out there. It turns out that a few of the justices on the court were appointed by Pete Wilson, and he personally intervened. He wrote a brief supporting the Jarvis opposition. The Howard Jarvis Taxpayers Association has been a stalking horse for, shall we say, non-progressive causes for many years. And so I would say that they were not the only opposition. They were the vehicle by which the opposition made itself known.
All right, any more questions in the audience? It's almost time to wrap this up, so we'll go one more here. Just hold on for the mic. Okay.
Yeah, I'm sort of a simple man. It seems to me that corporate personhood is pretty abstract. I was wondering if you could spend a minute or two why somebody should care about this really. Who is being hurt by this, and how are they being hurt?
Good question. A couple of quick examples of how corporate personhood plays out in the real world.
There are numerous examples. Let me give you one. In 1922, there was a case, the Pennsylvania Coal Company against Mahone, where the state of Pennsylvania passed a law basically making it illegal for corporations to dig underneath homes because the homes were collapsing. The coal company sued, claiming that their profits were affected and that this, in fact, would be what's called a taking under the Fifth Amendment. And the Fifth Amendment says that if the government passes a law that takes your property, they have to reimburse you. So the court ruled that the state of Pennsylvania would have to reimburse the coal company not only for its lost profits now, but for its future lost profits. The state of Pennsylvania decided to repeal the law because they couldn't afford the judgment. That's one example. There are many more.
I think one that always strikes me is that people know we have food safety laws in this country, and that the USDA is out there, Department of Agriculture, inspecting food places. What few people don't know is that the manufacturing plants claim the right under Fourth Amendment against unreasonable search and seizure. So none of these inspections are surprise inspections because they have to be notified ahead of time because the corporations wield their Fourth Amendment rights.
They need a warrant.
Yes, even actually, yes, they have to go through getting a warrant. All right, we are just about out of time for this segment. Any quick closing thoughts?
Bruce?
Well, just one quick example of, or really a metaphor. If corporations have the rights of people to free speech, then what they're able to do is buy a much bigger and louder megaphone to get their word out, using their money to influence the legislators, to give them access, to give them partnerships, and the result of that is that they have a much larger impact on legislation, on our democratic process. And if they're steering the benefits of that into their campaign coffers, the money that they have reserved for future campaigns, it becomes a vicious spiral. Or for them, a virtuous spiral. It just gives them more and more power, and more power over our democracy.
Closing thought?
I think Bruce said it eloquently.
Okay, we've been talking with Bruce Preville and Eitan Fenson from the Yes on Prop 49 campaign and Move to Amend Santa Clara County. I thank you both for joining us, and good luck with all the future efforts. I'm sure we'll have you back because, as Bruce put it, this is a long-term struggle.
Indeed.
Thank you.
Okay.
Thanks, Paul.
Thank you all for joining us here in the studio, and those of you watching at home and on the internet.